Good morning, Jackie. How are you today?
Good morning, Sarah. I'm well. Even though the sun's not out today, I am well still.
No.
I'm looking forward to this particular podcast, dealing with some more myth busting in terms of behaviour within family cases and family issues. This is quite a huge area.
Yeah.
We could go in all sorts of different directions with this one. So I think we'll try to keep it as focused as possible, and hopefully it will be informative and entertaining at the same time. So I think we were looking at starting with perhaps behaviour within divorce proceedings.
Yes, it seems like it's the start of the process, isn't it? And it's probably where a lot of the myths come from. It's probably the best place to start and then work on through where other myths are and where behaviour comes in other sort of areas.
That's right. It sort of seems like the sort of logical beginning. Obviously, when we see our clients, it's not always the start of us looking after them, but it's quite often where we begin. So with divorce proceedings, so obviously there's been a lot of talk about the law changing recently, but we're still predominantly dealing with a law that dates back to 1973 and all of the different nuances of the law at that time and how people were living, and really very much about looking at this sort of archaic view of punishment, really, of the person who is at fault should be punished, and therefore the proceedings should reflect that in some way. And we're obviously now trying to steer away from the idea of fault and a fault-based divorce. But for a lot of people, it's been the case that when they do want to actually finalise things, and sadly they've come to the conclusion that the marriage is over, they need to or want to base it upon the behaviour of the other party. Now, as a resolution family member, probably very much like yourself, Sarah, I quite often leave out the unreasonable bit when I refer to behaviour, when it's the fact that our clients want to rely upon or have to rely upon. So in the past, it would be generally a case that somebody felt obviously that the marriage was over, it was intolerable for them to remain together, and they had to rely upon some sort of allegation about the other party. And we might say to them, well, perhaps come up with 4 or 5 different examples of that behaviour. That could cover the whole gamut in terms of we don't really get on, we haven't got much in common, we've drifted apart, to the other end of the spectrum, sadly, of really serious violent behaviour, domestic abuse, all sorts of issues along the way. In terms of how behaviour at this end of the scale might impact on the divorce proceedings, it's generally the case that if it's at that, when I say lower level, that's not to in any way diminish it in terms of the importance or impact of that behaviour. But if it is more at this level, it's very rare that's going to have an impact on how the divorce continues, how the finances are resolved as part of that divorce, or anything else really. If it's based on the behaviour of the other party, then there's a natural presumption that costs will follow, that you have the party who's at fault and they will pay the costs or make a contribution towards the costs, but hopefully some sort of agreement can be reached. And this has caused a lot of unnecessary acrimony and additional conflict for separating parties for some time. I think in the last podcast, I mentioned the fact that when I had a client, a couple in fact, who didn't want to refer to behaviour against one another, but the whole court process and the law, the prevailing law, sort of made it a case of having to say something. So then obviously we've got the entrance of the long-awaited new law, which is there on the horizon now. So I think we're looking at 6th of April 2022 at long last. So we had Brexit come in between and go, and now at long last we've got the law that we wanted as lawyers and as clients for the general public. So it slips off the tongue nicely. Divorce, Dissolution and Separation Act 2020. So that in itself will allow parties to actually divorce without having to wait for 2 years, and also not, there's no need, they don't have to refer to any behaviour. So that is a more conciliatory way of divorcing. But you're still going to have cases, obviously, Sarah, in which people do want to rely upon behaviour and do want to make that the foundation. So I would say from my experience, I've had very few examples of where the behaviour within the divorce has actually made a difference in terms of giving that party an advantage. No, otherwise, right. In terms of the finances, I'm guessing that's sort of your experience as well.
Yes, yeah. And I think in terms of, as you were saying, there's two ends of the spectrum, and you have quite a lot of people who come in and they don't want to make it acrimonious. They want to keep tensions down as much as they can. And if they can put in, I mean, going ahead on a no-fault basis is going to improve that no end. But those people who are able to possibly agree lower levels of behaviour to put into the petition, as long as it's enough to actually satisfy the judge the marriage is broken down. But those may be the people that actually are able to reach an agreement in relation to finances, and they save in terms of costs, in terms of human cost as much as financial cost, but they save costs because they're able to settle it without a long contentious court battle, which costs thousands and thousands of pounds. So often we'll see people who will, or sometimes we'll see people who will want to put in as serious allegations as they possibly can, but that's not always going to be to their benefit, particularly if that behaviour isn't serious enough that it would have any consequence within the financial proceedings anyway.
Yeah, absolutely. I mean, I've seen it quite often that it's a little bit of a Pyrrhic victory. It's a matter of principle for a lot of people, and we're very sensitive to that as family lawyers, that people do feel, you know, I want to put this in, this is really important to me, it did make a difference, I need the judge to know. And it's getting that differential between that which could actually have a bearing on things in the future, and that which is very personal and means a lot to them. I only had one case, very sadly, in which the broad details were that I was looking after the wife, and unfortunately the husband had various relationships with wider family, let's put it that way, and it then obviously led to a breakup of the in-laws, the whole extended family unit. And it was really quite exceptional, and as the law says, you know, gross is in terms of the definition. And that was somewhere I actually, in that case, I did advise my client to not only rely upon it within the divorce proceedings, and of course costs followed on that, but also within the finances. So when it came to negotiating the finances and filling out the standard Form E financial statement document, where you basically swap your financial disclosure, in section 4 as to conduct, we referred to that background, which was a really unpleasant and upsetting background for my client, and the impact it had on the family as a whole. There were children involved, etc. And on that occasion, which was quite exceptional, the court did take that into account, and it did actually have a bearing and did influence the financial outcome. So it wasn't just a matter of costs being awarded on that occasion. It did impact in terms of who got what as well. But I say it's very rare that it comes up to that extent. It has to really be a case of, will there be inequity if in fact this isn't looked at? Is there going to be something that is unjust or unfair if this isn't looked at? Whereas generally speaking, it's not going to make a difference.
No, and I think there is it's a common misconception that, I mean, some people will come in and ask, my other half has committed adultery, does that mean I'm going to get more? Does that mean they've given up all of their rights to anything? That kind of behaviour is not going to be taken into account.
No.
It has to be gross or relating to financial misconduct. That would then be behaviour that could be taken into account. But in FS and JS in 2006, the judge gave some examples of behaviour that would be personal behaviour that could be taken into account, and they were very severe. It was when the wife stabbed her husband shot his wife, or the husband committed incest with a child of the family. So they are very, very serious instances of behaviour, and it's really unusual that someone's behaviour will impact on the financial outcome.
Absolutely, and they're really obvious and very visible, aren't they, in terms of those examples?
Yes.
So no doubt in those cases there were connected criminal proceedings, you know, if not in all, but definitely in some, and other proceedings that follow from that, and other actions that are taken that follow from that, which would provide evidence for that which is being relied upon within the divorce proceedings as well. And I think that's something that we're looking at separately, aren't we, in terms of our podcast in the future, in terms of the domestic abuse issue.
Yes.
And how far-reaching that can be. So at the moment, in terms of what we're looking at here, we accept that there is that extreme level, and that's going to be really quite obvious. And you sort of, it's like one of those things, you know it when you see it.
Yes, yeah.
And then that can have an impact on children's proceedings, so Children's Act proceedings in terms of welfare issues about children, and also injunction proceedings when it comes to domestic abuse. And that's something that we would look at separately, because that is huge in itself, isn't it? Yeah. So at the moment we're looking at generally what sort of occurs, sadly, which is very personal and very upsetting for people, but things that come up quite often, and which in themselves then really start sort of creating a myth when they do come about, and sort of common questions that we get from clients about things which sadly are intrinsically part of the case quite often.
Yes, yeah. And I think I touched upon financial misconduct, and one of the questions I commonly get asked is about holding assets. So if somebody's got funds, can I spend those funds? I've got £100,000. If somebody's dissipating assets to defeat the other party's claim, that is conduct that will be taken into account and will affect the financial proceedings. Again, it seems quite obvious when it's there, but it can be done more sneakily. So it's that kind of conduct that the court would be looking at, rather than somebody's committed adultery or has gone out all the time, or that kind of conduct isn't relevant to the financial proceedings. Financial misconduct, dissipating assets, or very, very serious misconduct is the conduct that the court would be concerned about.
Yes, it's and sometimes, as I say, we've been saying it's very obvious. Sometimes it's a little bit blurred. There is a grey area. So I'm just thinking, while you were talking there, Sarah, it just occurred to me about another a common one which comes up is in terms of access to, or somehow gaining access to, documents belonging to the other party. So there's lots of specific law in this area in terms of privacy, confidentiality, etc. So that's quite a common one, that sometimes a client will want to present us with documents which have come into their possession somehow. Various issues with that. There's also issues sometimes in terms of perhaps, in relation to maybe domestic abuse cases, but it can be a standalone situation of somebody trying to change the locks to a property. Yes. So we have that, and that's quite a question that revolves quite often in a case, as to somebody's changed the locks, someone else is going to change them. It's a civil matter. There's been no disturbance. The police won't get involved. But does that have a bearing on anything? And then also things like covert recordings. This one comes up pretty often in terms of our client or the other party recording on their mobile phone or otherwise a conversation, or it could be a session of contact with a child, if that's a particular issue that's in question, and how that could be used or not in some circumstances. And again, the law is changing to some extent. The general position seems to be the courts use quite a broad brush approach to these issues, and it will depend on the facts of the case as well. In terms of the finances and Section 25 factors in terms of Matrimonial Causes Act, who gets what, you're still going to be looking at need.
Yes.
At the end of the day, you're going to be looking at need. There's a whole list of other factors to be taken into account in terms of disparities and differences between the parties, but you're looking at need. And so for something of that degree, it needs to be of a magnitude which really is going to have a huge impact and take it away from that starting principle of, this is what the parties need. And sometimes it can take it back to a sharing principle.
Yes.
So it's quite interesting in that respect. And obviously we deal with these issues as they arise, and they are peculiar to the case in question. But generally speaking, the court is going to take a view, and it's possibly not going to be as definitive a view, or as as our clients would like, or as helpful a view as our client would like, because really they're trying to cut to the chase and come up with a fair settlement at the end of the day.
Yeah, and the judge is looking at that bigger picture.
Bigger picture.
Like you say, guided principally by needs. The other factors are obviously taken into account.
Yeah.
Weights attributed to each will be determined in each case, but often the behaviour becomes too. It's almost the nitty-gritty that isn't going to affect that bigger picture, and therefore it's disproportionate often to raise issues of conduct.
Yes.
Because the cost of doing that outweighs what any benefit that you might get, even if the court did take that into account.
Yeah, absolutely. Because traditionally what should happen is, if you are actually pursuing conduct, so quite often somebody might hint at conduct at some point when there's a first voluntary exchange of formal financial statements, and then further on within any proceedings or otherwise, then again you're asked, well, are you actually relying upon conduct? Do you want to pursue this? If you do, then the court has a duty to actually set time aside to hear those issues and determine them on a factual basis, on an evidential basis, and test them. And that's all additional time and cost. So you, as you say, Sarah, you've really got to weigh up, is it worth it? And what will be the outcome of that in itself, whether in fact they're deemed to be truthful in terms of the allegations, and even if they're deemed to be truthful, are they relevant and should they impact on the finances? So what we would say, obviously, you know, we need to know these things, and we need to be able to assess it in terms of our clients' needs as to whether that will have an impact. And we're also mindful of the sensitivities and how important it is, you know, these issues can be to our clients. I'm just thinking about another area as well, Sarah, in terms of, so we're talking about personal behaviour, and we've also spoken about financial conduct, which we know can have a huge bearing in terms of the outcome of proceedings, but also in terms of litigation conduct.
Yes.
So how the parties and the lawyers, how anybody involved in the case actually deals with that case, and how cooperative the parties are, how engaged they are. Is there a willingness to negotiate? Is there an atmosphere, a culture in which offers to settle are being made openly?
Yes, and that's an area of conduct that is probably more likely to result in cost orders.
Yeah.
It's unlikely it's going to affect the outcome of how the assets are divided, but it could result in cost orders that if you refuse to negotiate, or you refuse to put forward sensible offers, because you can be putting forward offers that are completely unreasonable just to look like you're negotiating, but if you refuse to enter sensible negotiations, the judge could order that you pay the other party's costs. And I think that is going to become an increasing risk as the law changes and there's more onus upon us to put forward open offers of settlement at the first opportunity that we're able to, once we have an idea of what the assets are available.
Yeah, and it kicks us all into touch, actually, doesn't it? Because it's saying, look, you've got these proceedings. Truly speaking, there may have been an opportunity earlier on, and maybe still, to go in a different direction with arbitration, mediation, collaborative law, but you've decided, for whatever reason, or compelled yourself to actually go down this road. And if you're doing that, then you still have an onus. There's still a duty to actually behave in a certain way and keep the processes efficient and as respectful as possible, and to also assist the court, because as we know from our experience, the court's completely inundated with cases left, right and centre in terms of the variety of cases, and so the system actually needs us and our clients to fall in line, basically, and do what needs to be done and keep things moving in a smooth way. And it's
to recognise that the court should be the last resort.
Yes.
And the final hearing should be the last resort, and that you have tried to do everything you can to settle things beforehand without the need to spend costs and time arguing when it could have been settled before.
That's right. That's right. I mean, when there was a huge surge and cultural move towards going down the mediation route, if it was applicable for clients, then there seemed to be a steering away from that, and there seemed to be an acknowledgement that really court was the last bastion. That really was the last resort. But I don't know, there seems to be a little bit of a movement heading back to court in terms of proceedings being issued, rightly or wrongly, for good or for bad. And maybe that's also brought about then a change in the cost directions and how the court's dealing with things. I mean, just in terms of bringing a bit of law into it, Sarah. So practice direction, which is actually, it was 29th of May 2019 in terms of costs, was updated in 2019 to deal with a slightly broader approach to costs in terms of how costs are actually looked at. That basically there's an onus on the parties to make those offers to settle. Okay, and that the court will look more harshly at these things if not, and also really emphasising to the parties that there's no presumption of costs. I mean, this is something else which quite often we deal with in terms of myths, that this winner or loser mentality, winning or losing, I have won, therefore I will get my costs. That presumption really isn't there. The presumption on first instance is a client is responsible for their own costs. And it's only then how it plays out, if there is litigation conduct or other issues which arise, that will be altered in any way. I think for us as practitioners, it seems to be that the new way forward is that we're looking at making offers in an open, ready manner. So making sure that we're efficient in terms of those offers and actually keeping the case moving and looking really logically and sensibly at how we can realistically help our clients settle, on a happier basis, rather than just, having more litigation. And also in terms of maybe looking at the drafting more specifically when it comes to orders. So, you're looking at costs in the application rather than perhaps not putting anything in about costs, assisting the judge, that sort of thing. So it is really also about us as professionals doing the right thing by our clients and the court as well to assist that process. I'm just trying to think in terms of litigation conduct. I've had two situations going way back where I had the other party acting in person, so litigant in person, and that was predominantly with both of those, it was about the lack of cooperation, the lack of engagement. I had husband on the other side who was a heavy drinker and had no wish or intention to get involved in the proceedings, and it really was like pulling teeth, and eventually the court made an order in my client's favour in the absence of that party. I had somebody else on the other side who failed to complete their Form E financial statement after several requests, and obviously then you've got the court having teeth such as penal notices and enforcement orders, and then you've got the whole cost of enforcement. But it takes something quite extreme for the court to determine actually enough is enough. We've given you enough chances now, and in fact this breach or this blatant flying in the face of the court process is going to end in an order which is going to be made and imposed by the court. So that's quite frustrating for clients as well. I think that it's quite an understandable presumption that if the other party isn't playing ball and not engaging, or they've done something wrong on at least one or two occasions, that will be the end of it, and therefore the whole case will then swing completely in the favour of our client.
I've had similar cases, litigants in person who refuse to engage at all, penal notices and cost orders, and that will be the way that the court will go, rather than necessarily affecting the financial settlement. I think it should be the cost orders that are the punishment, and the penal notices to get them to actually to comply. But I think we've obviously talked about the drive for negotiation and open offers and settlements early. The vast majority of matters do still settle by agreement without the need for a final hearing. So it is working, the system is working, and it isn't always necessary to look to those behaviours to improve your financial settlement. I think it's better to do things by agreement, because you can get a settlement that works for everybody rather than something imposed by the court.
Absolutely. I think it's also about us doing the best for our clients and using our skills to pace things and go on that journey with them, because at the very start everything is raw. Everything is raw. Everything is, can be awful, and it is that grieving process of actually this has happened to me, and it's the very personal, and it's us being able to then assist by taking a view and saying, well, actually it is it is as it appears at the moment, but as time moves on, maybe that particular issue will not seem as bold as things move forwards, and therefore, you know, will not seem as relevant or as important, because other more major things will come into play.
Yes, yeah, and you're right, and helping them to see the aspects of behaviour that are relevant and raising them will help, and those that actually it can be counterproductive to raise this, because it's just going to make it even more acrimonious between the two of you, more difficult to negotiate sensibly, and more difficult for them to move forwards, particularly if there's children and they have to be involved in each other's lives going forwards, because actually the best thing we can do is help them to reduce that tension and work forwards together, although they're separately, they can still be united in their parenting.
Absolutely.
I think we probably covered everything in relation to myths, sort of behaviour with divorce and finances. Was there anything more?
I think the only thing I can think of, actually, just coming back to the divorce, in fact, so complete rewind to the beginning, is that another issue is also, as part of that, the actual set divorce process, sometimes clients have asked me, so who will know about what's been said in the petition? So obviously on the making of decree nisi, the classic scenario being of the names of the parties being on the board, but obviously no particulars, no statement of case. So that whole issue as well, that sometimes for clients it's very important to get it all out there in the petition, thinking that either it will be shared with everyone, or that in fact, or concerned that it will be shared with everyone, and it's very much a private document unless, you know, they choose to share it. So that's something which has come up before, which just occurred to me.
Yes, yeah. Some people are very, and it's a principle thing, isn't it, that they want it noted what the actual reason was, and known. But actually, as you say, it's a private document that they're only going to share with whoever they choose to share it with. So, well, in terms of our next video podcast, we will be continuing on with the behaviour, but in relation to children, how it affects children at proceedings, and drawing into that domestic violence and injunction proceedings. So that will be online in about a month, I would imagine.
Yep, seems about right.
Yep, perfect. Well, it's lovely to see you, and we'll speak again soon.
And you, and thank you for listening and watching, everyone, and we'll see you soon. Take care in the meantime.
Bye-bye.
Bye-bye.